Lordship, Lordship, I am praying for listing of a criminal matter today, Lordship. In fact, we have filed it yesterday and the case is numbered also, but somehow it is not listed today, Lordship.
Motion.
Motion matter.
Motion. Okay. Just go.
Obliged.
Yes.
Please, Lordship. I would beg to mention item number 15 for hearing.
15. Yes.
15. Item 15 is linked with 16. And in the item number 16, the petitioners, they have filed an additional affidavit just recently. And I have perused the affidavit. On perusal, there are some pertinent documents which I may need in order to determine the case even in 15. If I may be allowed to file additional affidavit to enclose some pertinent documents.
Okay. In WP 152, you are the respondent.
No, I'm only petitioner in 15. There's no private respondent, but both are similar matters, analogous matters, Lordship.
Lordship, in fact, in item 16, as stated by my learned friend here, the petitioner here have filed an additional affidavit. I also need instructions in this, and they have filed it on 11th. Yes, so if
11th of this month.
Yes, Your Lordship. So if 3 weeks time, Your Lordship.
Learned Counsel for the petitioner, Mr. Mua Jamir, in WP 73 of 2024, submits that the petitioners in WP 52 of 2024 has filed an additional affidavit recently, i.e. only on 11/11/2025, wherein they have enclosed certain documents which he would like to examine and file reply if necessary. Stop. Learned Government, Senior Government Advocate, Mr. N. Nangami, also has a similar prayer with respect to the additional affidavit filed by the petitioner in WP 52 of 2024. Stop. Accordingly, list the matter after 3 weeks.
Lordship. Deeply obliged.
What's why I also like to mention item number 9.
Okay.
Item number 9.
In WP 52 also, the petitioner was there. What was his name?
Aliba.
Aliba Uzakam, no?
Yes.
Yes, item 9.
And item number 9, the government, they have already complied, Lordship. This contempt may be closed.
Okay. Any document are you producing?
Lordship, on day before yesterday, we have produced the document before Lordship.
Yeah, that's it.
Okay. Can you just give me the file? Yes, you wanted to get some instructions.
Yes.
Learned Counsel for the petitioner, Mr. Mua Jamir is present. Learned Counsel, Ms. V. Shukri is present for respondent number 2, and Mr. N. Angami represents respondent number 1.
And my Lord, M.
And Mr. M. Longcomer
for
appears
respondent number 3.
Number 3. So, by letter dated 31/10/2025, which is on record, which is placed on record as Annexure X, the direction of this court in order dated, what was the direction? Order dated
12/3/2025.
such in WPC
WPC number 209 of 2024.
209 of 2024 has been complied with. Stop. Accordingly, the matter is closed and disposed of.
Much obliged.
Obliged.
May I please, Your Lordship?
Yes.
I beg to mention item number 4. Lordship, here I'm preparing for affidavit, so kindly grant 3 weeks of time to file my affidavit.
3 weeks.
Lordship,
What about petitioner?
item 4.
Learned counsel for the petitioner, 3 weeks. Ms. Kim Pen here is present. So, Learned Government Advocate Mr. A. Samtam prays for 3 weeks' time to file the affidavit on behalf of the state respondents. So, praise the Lord, list after 3 weeks.
Kindly oblige.
May I please, Your Lordship?
Yes.
May we please to mention item 6, Your Lordship.
Item 6.
Your Lordship, I could not able to get the instruction again. So if the matter can come up on Monday, Your Lordship.
This is the Zima petition.
Yes, my petition. So on Monday, Your Lordship.
You need to get the case
Yes,
diary.
yes, Your Lordship. I could not able to get in touch with the IU.
Okay, Learned PP, Ms. Livika submits that she is unable to, she is not able to contact the IU of the case and therefore prays for listing the matter when?
Monday, Your Lordship.
On 24/11 for producing the updated case diary. So, Learned counsel for the petitioner is not present.
I've taken the consent. He's in the.
Okay, okay. It is stated that the consent of the learned counsel for the petitioner has been obtained. So, list on 24/11. Yes.
Your Lordship, I also beg to mention item 1. Your Lordship, this case is already under consideration, and today I was supposed to bring the status as to what is the current status of the consideration, Your Lordship, and I am informed that the case has already been forwarded to the finance again. Finance, Your Lordship.
Finance.
Yes, Your Lordship, finance section.
This is for what?
Your Lordship, this is for
Regularization.
regularization, Your Lordship. So, Your Lordship, let it come after vacation only. Since we will not be able to get it in this time.
Learned Government Advocate Ms. Livika submits that the regularization of the petitioner is already under process and the file has now reached the finance department or finance department. So accordingly, she has submitted that the matter may be listed after the winter vacation.
I've taken the consent of the petition.
So it is also submitted that the consent of the counsel for the petitioner has been obtained. So list after winter vacations.
Much obliged.
Please, Your Lordship, I'd like to mention item number 2. My question is, I'm mentioning on behalf of my senior counsel, P.N. Sharma. Kindly allow us 3 weeks' time to file our objection.
Okay. In IA 54,
Yes, Your Lordship.
Learned Counsel, Ms. Sarjan Such, praying on behalf of the leading counsel, Mr. B.N. Sharma, submits that they would like 3 weeks' time to file an objection in IA 54 of 2024. So accordingly, prayers allowed, list after 3 weeks. Yes. What about appellant? Have you informed them? Learned counsel for the appellant is not present when the matter is called. So, yes.
Much obliged.
Your Lordship, I beg to mention hearing item number 17.
17.
I request that a week may be granted.
1 week.
Yes.
On behalf of?
Cindy Younger, respondent number 2, 3, 6, and 7.
What about the petitioner? Petitioner is not present.
I have taken the consent from the petitioner.
Okay. Learned counsel appearing for MS Sarjan Search, appearing for respondent number 2, 3, 6, and 7, mentioning on behalf of the leading counsel, Mr. Cindy Younger, prays for listing the matter after a week.
A week.
After a week. So it is submitted that the consent of the counsel for the petitioner has also been obtained. So please after 1 week. Yes.
For motion from the supplementary court, please. Item number 18.
May it please Your Lordship. Lordship, this application is filed under section 483 and section 187.3 of the BNSS. I'm seeking bail on the full ground, my lord.
Okay, we'll have to see the case diary. Right, learned counsel for the petitioner, Mr. A. Sophie. So the present application under section 483, read with 187 clause 3 of the BNSS has been filed, praying for release of the accused persons too.
Yes, my lord. 6 of them.
Oh, accused persons on bail. Stop. Learned PP, Ms. Livika appears for the respondents. Stop. List on, when can you produce? 27th. 27, 28, or it's up to you. 28, 28. List on 28, 11, 2025. Stop. On the next date, the learned public prosecutor.
My lord,
You can make it
kindly
two
allow
so
me
that
to
informant-
issue notice to the respondent number 2, the informant.
Informant is also there. Oh, yes, yes, POXO, no?
Yes, my lord.
Yes. Oh, then in that case, it
Yeah, let
can't
it
be, it can't be.
in December.
Yes. Issue notice return within 2 weeks. Can you serve within 2 days? Where is he from? He or she?
Katashe, Pukuboto.
Pukubuto. Oh.
My lord, may kindly allow Dusty then, and Eddie also.
Notice returnable within 2 weeks. No? The learned government advocate BP Ms. Livika accepts notice on behalf of the state respondents. So the learned counsel for the petitioner shall take steps for the respondent for service on the respondent. Where is that? In your course title, in the matter of such and such, Avi the assumed petitioner versus state member. Okay, 2, no?
Yes, my lord.
Inako Heto, this one.
Yes, my lord.
On the respondent number 2/informant by speed post document as well as Dusty, as well as by Dusty mode, and thereafter to file an affidavit of compliance. The petitioner shall take steps within 2 working days from today. List after 2 weeks. And on the next day, the learned public prosecutor shall also produce the updated case there.
Obliged, my lord.
For motion, item number 19.
Yes, which order?
Your Lordship, the present contempt petition is for non-compliance of judgment and order dated 26/09/2024, disposed in WPC 317/2023.
Where is that? Where is the judgment page?
Judgment order which is annexed in Annexure A, page number 24, point number 15.
Para 15.
Yeah.
Right, learned counsel for the petitioner, Mr. Such and Such, your name. Stop. This application under section 12 of the Contempt of Courts Act 1971, read with Article 215 of the Constitution of India, has been filed alleging willful disobedience of the judgment and order dated 26/9/2024, passed by this court in WPC 317/2023. Stop. The submission of the petitioner is that by order dated 26/9/20, judgment and order dated 26/9/2024, passed in WPC 317 of 2023, the respondents / contemners had been directed to advertise the post of Sub-Inspector of Police slash unarmed branch sub-inspector of police slash assistant sub-inspector of police slash instructor havildar within a period of 6 months, isn't it?
Yeah,
Within
6
a
months.
period of 6 months from the date of the order. Stop. Issue notice returnable within 4 weeks. Stop. The petitioner shall take steps for service on the respondents number 1, 2, and 3. No, respondents number 1, 2, and 3 by speed post document as well as the usual process within 3 working days. List after 4 weeks.
Your Worship, I would also like to file talabana to respondent number 1, 2, and 3.
No, usual process means talabana. You take steps in the registry.
Okay. Okay, thank you, Your Worship.
So motion from the supplementary post list, item number 20. Unlisted motion.
May I please, Your Lordship? I have a very limited prayer, Lordship.
Have you served copy on the prosecutor? Public prosecutor?
Yes, Lordship, yesterday.
Copy just now.
Lordship, by FIR dated 6/9/2023, that is Annexure 6, page 42, but relevant is page 45, Lordship.
Page 45.
Yes, Lordship, it's a typed copy.
Yes.
Lordship, may I read the FIR?
Please read.
On 5/1/2023, on the instruction of one person, namely Mohan, a sum of rupees 6,58,000 was drafted in the bank account number so and so belonging to one Swapnil Sekya. Lordship, Swapnil Sekya is the petitioner.
Okay.
On the promise that he shall deliver the construction materials to me. However, even after a lapse of so many months, the required material has not been delivered to me. Despite of all my efforts to amicably settle the problem on our individual level, both the aforesaid persons are not cooperating by means of taking unfounded excuses and also by evading from me. Mention may be made that I even went to the residence of Mohan for 3 consecutive times at his native place, Tipuk, Halwading, under Shivsagar, Assam. In the process, I was otherwise constrained to suffer additional monetary loss at the cost of their fault. Hence, you competent authorities requested to investigate the matter and initiate appropriate action against them for seeking criminal breach of trust and causing wrongful loss to me. Lordship, I have stated in my petition that the petitioner hails from a remote place near the Amguri border, Lordship, and even some people in his place does not even today have the bank account. So, Lordship, the petitioner knows one person, namely Kalyan Patar. Petitioner did not knew Mohan earlier. So Kalyan Patar was his childhood friend. One day Kalyan Patar took the other accused, Mohan, to him, that the Mohan, the other accused, was supposed to receive some money from Nagaland. So they asked the bank number of the petitioner, Lordship. Otherwise, the petitioner is an employee in a private company called Bajaj Finance Limited. Lordship, believing his childhood friend Kalyan, he provided his bank account number to Mohan, Lordship, the accused number 1 herein. Thereafter, he did not know. Thereafter, he even withdrew the money on the request of Kalyan Patar, Lordship. I have annexed the bank statement also. The money was deposited to the account of the petitioner on 5/1/2023, and it was withdrawn and on the request of Mohan, their business partner, Lordship, on 6th January and 7th January, Lordship. Thereafter, only the petitioner came to know about the present case, which is pending before the Lanet Season Sang, Lordship. But due to his service and the requirement of his job, Lordship, he could not follow the matter. He only appeared once before the Lanet trial court on 26/6/2024. Thereafter, he was told by Mohan and Kalyan that some amicable settlement was going on. Under the bona fide belief and ignorance, Lordship petitioner was not aware that some orders by the learned court seeking the appearance of the petitioner has been issued, Lordship. The order I have mentioned in
Where
my...
is that? Annexure 7.
Lordship, Annexure 8, page 50 to 58, Lordship. The learned court issued bailable warrant, but Lordship petitioner apprehends that due to his prolonged absence, Lordship, although the certified copy, it shows that the next date fixed was on 19/11, I am instructed by the council in the Tuensang that date was refixed and rescheduled on 25th of this month, Lordship. So my limited prayer, Lordship, I will go and appear before the learned trial court, Lordship, but no coercive action in the event of my appearance there, Lordship.
Heard learned counsel for the petitioner, Miss such and such, your name.
And Bora, Lordship.
The present application under section 528 of the BNSS has been filed, praying for setting aside and quashing of the orders dated. You just see from the cost title, there are many orders, okay? Starting from 25/2024 till 10/10/2025. Passed in PRC case number 1/2024 by the Judicial Magistrate First Class Tuensang, Nagaland, in connection with GR number 60/2023 arising out of Tuensang PS case number 45/2023 under section 420/34 IPC. Stop. Para. The case of the petitioner is that he hails from a remote area in Sivsagar district, Assam, bordering the state of Nagaland. Many people of his village do not have bank accounts, and therefore, on request of known people, the petitioner had to provide his SBI account number to other people for emergency transaction of money. Stop. During the month of November and December of 2022, one Mohan Rabha, M-O-H-A-N, Mohan Rabha, R-A-B-H-A, had come to meet the petitioner, and since he was a along with one Kalyan Pator, K-A-L-Y-A-N, Kalyan Pator, P-A-T-O-R, along with Kalyan Pator, who is a childhood friend of the petitioner. The petitioner, who had asked for your account number? This Mohan Rabba, na?
Yes, Lordship.
The Mohan Rabba requested the petitioner that he was supposed to receive from money from Tuensang, Nagaland in connection with the business, and since he had no bank account of his own, Mohan requested the petitioner to provide his SBI bank account number for his transaction. The petitioner allowed Mohan Rabba to use his SBI account number for his business transaction. Stop. Accordingly, on 5/1/2023, an amount of rupees 6,58,000 was credited to the SBI account of the petitioner through a check number 021958. Stop. Thereafter, Kalyan Pator met the petitioner on 6/1/2023 and asked the petitioner that he and Mohan. Wait. So now finally the entire amount has been withdrawn.
Lordship, small amount has been kept in his bank, but it was given to the Mohan Rabha by case. But the bank record shows, Lordship, Annexure 4, page 38. Lordship, 6/1/2023, Kalyan Patra, Lordship. 1 lakh.
6/1. Okay, so according to you, now how much is left? He has withdrawn everything of this 6,58,000.
1 lakh, 5 lakhs is withdrawn and given to Kalyan Patra, the
5
common
lakhs.
friend. And a small amount, 1 lakh was given to, 1 lakh something was given to Mohan Rava by case, Lordship.
What did I say? Met the petitioner on 6/1/2023 and asked the petitioner that he and Mohan required only rupees 1 lakh out of the 6,58,000, which was credited to the account of the petitioner on 5/1/2023. Thereafter,
On 7/1, Lordship.
on 7/1/2023, both Kalyan Pator and Mohan again met the petitioner and requested him to release an amount of rupees 4 lakhs and rupees 40,000 through 2 different checks in favor of Kalyan Pator. Accordingly, the petitioner submits that a total amount of 5 lakhs has been given to Kalyan Pator and Mohan Rabha, and thereafter another 1 lakh was given by cash. Stop. The petitioner submits that he was surprised to receive the notice under section 41A CRPC through his WhatsApp number, directing him to appear before the Tuensang police station in connection with FIR number 45/2023 under section 420/34 IPC. Stop. The petitioner also states that in the impugned FIR dated
6/9/2023, Lordship.
6/9/2023, the present petitioner has been arraigned as the accused person and charged under the sections as mentioned above. Stop. Being aggrieved, the petitioner has come before this court, praying for quashing and setting aside of the proceedings before the Judicial Magistrate First Class Tuensang, Nagaland. Stop. Issue notice returnable within 4 weeks. Stop. Learned Public Prosecutor Ms. Livika accepts notice on behalf of the respondent number 1, State of Nagaland. Stop. What about the informant, the complainant? You have not impleted the complainant.
Lordship, we have not impleted, it's a state case, so except the POXCO matter, Lordship, we have not impleted the informant.
No. In a criminal petition, you have to implead. It's a 528 petition. Yes, you have to implead. You file an impleadment application. Okay.
Till then, Lordship, as the next date is 25th, Lordship, I may be protected. In the meantime,
No, that is a different matter, but the complainant also has to be heard.
Lordship,
so you
I
have
will
to file
file-
an impleadment application. Okay.
Lordship, I will file the necessary.
State of Nagaland. So, no. Till the next returnable date, the impugned orders dated 25/2024, such and such, passed by the learned judicial magistrate, first class Tuensang, in PRC case number 1/2024, arising out of GR case, PRC or GR? It is GR, not PRC. Say GR case number 60/2023, arising out of Tuensang PS case number 45/2023, shall remain state till the next returnable date. So the petitioner is directed to appear before the learned judicial magistrate, first class Tuensang. When can you appear?
Lordship, the fixed date is 25th, Lordship.
25th of this month?
Yes, Lordship.
Shall appear before the JMFC and such on 25/11/2025. So the petitioner is also directed to file necessary applications regarding improvement of the complainant.
Obliged, Lordship.
Least after 4 weeks now, I said, notice, yes, least after 4 weeks. Do
Obliged,
you need
Lordship.
extra copy?
Yes, Your Lordship.
The petitioner shall also supply an extra copy of the petition on the learned public prosecutor during the
Lordship,
course of.
today itself.
For admission, item number 5.
Complete. Last occasion, you were
Lordship,
saying,
on the last occasion, I have for time to obtain the
to
copy.
produce the order.
So, Lordship, here, I obtained the copy through electronic media only. So, whether that can be entertained. Because
Not the
these-
hard copy.
No, hard copy is I'm yet to receive. And Deputy Commissioner Zenebutu, I was told that they have already sent long time back. But in order to meet the requirement of the court, I have
Have you
obtained
given
it.
copy to them?
Yes.
You just examine. You have received a copy, no?
Yes, my lord.
So what was your prayer in the, what was the direction?
Direction of the Honorable Court was to assess the damage, alleged damage, and make an assessment in WBC 310 of 2023. So the damage, it was.
Dispose of, to dispose of the representation by, for assessment of the compensation by passing a speaking order. Okay, so now it's complete. Learned Counsel, Mr. In Tim Song, appearing for respondent number four, has produced a copy of the letter dated 15 May 2025, written by the Deputy Commissioner Zenipoto, Nagaland, to the Commissioner Nagaland, Kohima, submitting the damage assessment report in respect of the petitioner in compliance with the order of this court dated 30/4/2024, passed in WPC number 310/2023. Stop. The letter indicates that the damage assessment report amounting to rupees 1,57,27,958 has been worked out in respect of the petitioner, and the same has been forwarded for further necessary action. Stop. The learned counsel for you are appearing for Mr. Mua Jamir appears for respondent number 2. Respondent number 2 and Mr. N. Nangami for respondent number 1. Stop. The learned counsel for the petitioner, Mr. Patmin Chapu, is present. As the direction of this court has been complied with, the matter, the letter dated 15/5/2025 is placed on record as Annexure X, and the matter stands disposed. Yes.
For admission, item number 7.
Your Lordship, this instant make appeal is filed against the judgment, against the impugned judgment dated 19/6/2025, which is passed in MSC case number 54 of 2021, Your Lordship, in MSCT Dimapur, Nagaland, Your Lordship. Lordship, the brief fact of the case is that the respondent number 1 husband on 31/3/2021, an incident took place at Sansupe, NH 16, under Woka district, involving a vehicle BR number NL07 9947, Your Lordship, where the respondent Smriti Tsundenseng La husband, a pastor by profession, succumbed to his injuries on the spot, Your Lordship. During the time the vehicle was driven by Sri Kora Sashi Lemter. When the incident took place, the deceased was seated on the back side along with his mother, Smriti Temjemongla, and Sri Longlenliba, the father of the deceased, was seated on the front when the incident took place. The fact about the incident was duly reported to the Woka police station.
Just come to your grounds. On which grounds? On what grounds you are challenging? Yes.
My grounds will be starting from para 3, Your Lordship. For that, the learned tribunal failed to observe that Section 166 of the MVF, which is a platform clearly for the third party injury and death. But in this instant case, it pertains to the death of the insured owner, who is not a third party, Your Lordship. And my para 4, for that the learned tribunal failed to observe the company certified insurance policy in DW through Mr. Rensung Ta Lota, senior assistant, and the tribunal ignored the company defense plea, and the same was not discussed in the judgment. Your Lordship, supplementary to that, if Your Lordship may kindly come to annexure B2, page 31 of my appeal.
Page 31. Yes.
Supplementary to para 3 and para 4, Your Lordship, the car have been insured in policy zone B, private car liability, Your Lordship. The
Here,
vehicle.
what is the name of the insured here?
Insured name Pastor Borolengri Al Baptist Arago. It's under policy zone B, private car liability, Your Lordship. The vehicle Bolero has been insured under the Pastor Borolengri Al Baptist Arago, and insured was paid for private car liability only in policy zone B. Also, Your Lordship, in this instant care, premium has been paid for personal accident of owner cum driver, Your Lordship. Well, at the time of the accident, the insurer will be liable to pay the extent of rupees 10 lakh as per the policy. However, as per admitted by the claimant and as well as the police report indicate that the paid driver was driving and not the registered owner. And furthermore, no additional premium has been paid for the passengers, Your Lordship.
Wait 1 minute.
Paid drivers. The paid driver was driving the vehicle, Your Lordship.
So the Who was covered? The owner.
Yes, owner cum driver. But the car was driven by the paid driver during the time of the accident, Your Lordship.
Then
This policy zone B only covers for third party, Your Lordship. Coming to my para 5 of my ground, Your Lordship, page number 7.
yes.
For that, the learner tribunal has failed to observe that no PM examination was given by the claimant. In such circumstances, it is difficult to ascertain the proximate of cause of the death. Moreover, the principle of legal maxim which says he who seeks equity must come with clean hand has been violated, as the claimant only at the time of claiming benefit appeared to initiate the legal proceeding. Supplementary to my para 5, Your Lordship, it is a procedural rule that conducting PM report in RTA is necessary to ascertain the proximate cause of accident and also whether the driver was under the influence of alcohol at the time of accident. Thus, the claimant, by not allowing the conduct of the PM report, has not come before the court with clean hands, but only to seek the financial benefit, which is unfair and not as per the law. Your Lordship, as per the Supreme Court direction in Gore Muhammad versus State of UP, MA number 825/2023 in Civil Appeal number 9322/2022, wherein the SC directed all police station, tribunals, and insurance companies to provide accidental data information in order to carry out swift settlement relating to MSC cases, Your Lordship. If I may. Para 32, Your Lordship. May I read, Your Lordship? The investigating officer shall, within 90 days, compile all relevant documents and materials in the form of detailed accident report in Form 7, accompanying site plan Form 8, mechanical inspection report Form 9, verification report Form 10, and the report under Section 173 Code of Civil Procedure. It would be the duty of the registering authority to verify the registration certificate, driving license, fitness, and permit in respect of the vehicle involved in the accident, and the same is required to be submitted within 15 days to the investigating officer to complete the IAR and DAR. The extension of time limit to file the IAR and DAR is only permissible where the investigating officer approaches the claim tribunals in cases where party resides outside the jurisdiction of the court or where the driver's license is issued outside the jurisdiction of the court or where the victim has suffered grievous injuries and are undergoing continuous treatment. Thus, the investigating officer shall furnish FAR within 48 hours, IAR within 50 days, complete the investigation within 60 days, and file DAR within 90 days. Copy of DAR shall be furnished to the victim's owner, drivers of the vehicle, the insurance company involved, and the state legal service authority, including the nodal officer of the insurance company and the General Insurance Council. Your Lordship, para 33. On pursuit of the above, if it is clear that to carry out the purpose of the provision of Section 159 and 160 of the MV Amendment Act, the officer in charge of the police station and the registering authority are required to act upon in a manner as prescribed in the rules within the period as specified. Thereby, on receiving the information of accident, the complete information regarding such accident is to be made available before the claims tribunal within the time limit without delay. As per rules, the failure to perform the duties by the police officer may entail severe consequence as envisaged under the provision of the State Police Act. Thus, legislative intent is clear that on reporting a road accident, the investigation officer must complete all his action within time frame and shall act as facilitator to the victim's claims insurance company by furnishing all detail in prescribed form. Thereby, claimants may get damage compensation without delay, Your Lordship.
By this judgment, what do you want to show? That this 90 days, DAR and all that was not complied with?
Your Lordship, the post-mortem report was not given.
Post-mortem?
Yes.
Okay, then.
Coming to my next round, Your Lordship, page number 7, para 6, Your Lordship, that the learner tribunal failed to observe that the company counsel has specifically taken up the defense plea even in written statement, that the sum assured in personal accidental case of owner driver claims are fixed amount to extent of rupees 15 lakhs only as per policy terms and condition. And the tribunals in the judgment also noted about the instant case not being a third-party claim, but failed to decide the matter as per legal procedure. Thus, the tribunal erred in law by passing the judgment against the company along with excessive interest of 7.5 from the date of filing, and the award interest should be applicable in the present should not be applicable in the present case as the PA coverage amount is fixed, Your Lordship. Your Lordship, my humble prayer to this honorable court.
So ultimately, how much was awarded?
15 lakhs.
Where is the impugned judgment?
Page 11, Your Lordship.
So you are aggrieved by the interest,
Your Lordship, since the policy is only for third-party insurance, and also there is no PM report submitted by the claimants, and also the interest being passed by the tribunals.
So the person who died was the person who was covered, isn't it?
Yes, Your Lordship.
And then the person who was driving was the paid driver.
Yes, Your Lordship. And the policy that they have paid is only for driver plus owner cum driver, Your Lordship.
Driver.
Yes.
Okay, yes. Who's appearing? Is that all?
Yes, Your Lordship.
You are appearing for?
I am for claimant respondent.
Claimant respondent.
May it please your lordship.
Yes.
At the outset, the prison appeal filed by the insurer, the appellant, is not maintainable. That is one aspect that the court has to look into because here,
On what ground? 1 minute, okay.
yeah, they have not set out any proper ground in this appeal. On what basis they are preferring before this court? Here, it is a question of contractual liability. Now, even in the written statement, even in the appeal memo, they have admitted to the extent of 15 lakhs that they are liable.
Yes, that they have admitted.
That they have
So
admitted.
1, 2, 3, nah? That means you are 1, 2, 3.
Yes. So
And you are for 4 and 5.
one way they are saying that they are not liable. Other way they are saying to the extent that they are admitting to the liability of 15 lakhs. And if your lordship, we kindly refer to the documents that they have filed along with this memo of appeal. In my petition, it has not been marked, but page 31. Page 31. This is the insurance policy where the vehicle was being insured by this policy. And from the trial, at the trial stage, the insurance company, they've never denied about the factum of the accident, involvement of the vehicle. There is no denial. They've already admitted that there was a death, accident, and everything. There was no such issue concerning with the policy does not covers also. Now here, if your lordship may kindly I would like to take your lordship to page 32. This, so, what the learned counsel for the insurer says that it's a private car liability policy zone B. So, zone is a different aspect, but the premium that the company has received is to the extent of rupees 320. That means if page 32, column A, P, so in column P, 1, 2, 3. So there, the insurance company,
for owner driver.
yes, they have already received this amount. Given a contractual liability to the extent of rupees 15 lakhs. And one thing that this honorable court has to look into the aspects that there is no such rider in this insurance policy, otherwise there is no such condition that the owner should be driving at the time of the accident. But what they are saying is that the owner was sitting in the vehicle and the driver was driving. So liability to the extent of driver has also been given. Very unfortunate in one way to say that the accident has occurred in the pastor. The insurance was made in the name of Pastor Porolini of Baptist Church. And unfortunately that the pastor, Mr. Temsuwati, who happens to be the pastor of that particular church, while driving in the vehicle,
He's the one who died.
yeah, he's the one who died. So they are saying that owner has been involved, but he was not driving. That is the plea of the insurance company in this appeal, which is not a appropriate ground that they have taken. One way they are saying that they are liable, other way they are saying that he should be driving the vehicle. That is contrary.
Otherwise, it says here additional premium for owner driver.
Yes, even owner driver is also paid, as well as for the paid driver is been paid. So at this juncture, whether the appeal made by the insurance company saying that the the owner was to be at the wheel, that is not the proper concept of law. And when the premium has been accepted by the company to the extent of 15 lakhs, the tribunal has come to the conclusion that there is a contractual liability. So, without going to the merit of the case, otherwise to the extent of the claim made by the respondent claimant before the tribunal, It has come to a conclusion that there is a contractual liability which has not been denied by the insurance company, so the tribunal is awarded 15 lakhs. So what is wrong with it? And it appeared.
Let's see what the trial court said about this.
Yes. Shall I read from the beginning?
No. Only the observation.
Yeah,
part.
observation part is at page 24. Second paragraph, page 24.
Yes.
As far as the quantum of compensation to be awarded, this tribunal is of the view that since the liability arising in the instant case is based on the contract of insurance, wherein additional premium was paid for covering liability to the limit of rupees 15 lakhs in not statutory compensation, the tribunal is of the considered opinion that the liability of insurer to the entitlement of the claimant must be based on the contract of insurance. Accordingly, this tribunal award rupees 15 lakhs as compensation. Further, the claimant are entitled to the entries of rupees at the rate of 7.5 per annum from the date of filing of the claim, that is from 16/9/2021 till realization against the awarded amount. This is the observation given by the trial court, learned court below. So what is wrong with the order passed by the tribunal, learned court below? He has, within the extent, after analyzing everything, he has come to conclusion that there is a contractual liability. Other thing is that concerning with the post-mortem report, the insurance company had nowhere denied about the accident and the death. The question
That is admitted in the judgment also. It is said.
Yes, very
it
much.
is stated that the insurer also admitted to the fact that the vehicle such and such was insured to the company in the name of pastor such and such.
Then coming to the aspect of the judgment that my learned friend has relied, that is a different aspect. That is the role to be played by the
investigating agency,
not by the claimant to substantiate with all these facts.
That's why I was asking what the petitioner wants to show by this. And as far as post-mortem is concerned, death certificate is enough for MSC claim, because
if they dispute to a certain extent that the accident was of some
if
other
death is disputed, maybe.
Yes.
But in this case, death is not disputed. The insurer has already admitted.
Then coming to the part of entries that they have set out in the ground, Motor Vehicle Act Section 171 clearly gives a provision to the tribunal to award entries. So what is wrong with the award? Actually, the entries that is granted by the tribunal is much lesser than the entries granted by our Supreme Court, otherwise by the High Court.
As far as interest is concerned, that is okay, because
Yes.
discretion, it depends
Yes.
on the discretion of the tribunal.
So they are
Some may give 6, 7, some even give 9.
Yes. So, in my short submission, the appeal, the insurer has not come up with the proper grounds of appeal, where this court should interfere also. And the finding arrived by the tribunal has come to a right conclusion. So in this case, the other grounds are not relevant. If the company can come up to the extent that there was no insurance, then in that extent, this court can interfere. But the policy itself is there, which is covered, and the accident took place within the validity of the insurance policy. The premium has been paid, they have received, and there is a contractual liability to the extent of 15 lakhs. So in this case, there is nothing wrong with the finding given by the tribunal, and this the appeal filed by the insurer should not be should be dismissed. That is my brief submission in brief. But if my learned friends come up with other friends, I mean, given the opportunity to counter.
Okay, yes. Anything else?
Yes, Your Lordship, as per section 173 of the CRPC, police has failed on their part by not completing the PM report, which is necessary procedure because the lapses made by the police. Why would the insurance company suffer, Your Lordship?
No, but those grounds you have not taken before the tribunal. Before the tribunal, nothing was disputed. The accident was not disputed. The insurance was also not disputed. And when it is not disputed, then post-mortem report is not required. That certificate will suffice. Because in a motor accident claim, the burden of proof, I mean the proof is only a preponderance, not proof beyond reasonable doubt. Yes, that's all.
As my humble prayer to this honorable court is as to why the impugned judgment ordered 19/6/2025 passed in MSC 5421 should not be questioned, Your Lordship.
Okay, all right. This appeal under section 173 of the MV Act has been preferred by the Oriental Insurance Company Limited against the judgment and award dated 19/6/2025 passed by the learned MACT Dimapur, Nagaland in MACT case number 54/2021. Stop. Third learned counsel for the petitioner, Ms. Kim Penier, as well as Mr. Pandang Wapang for the respondent claimants number 1, 2 and 3, and Mr. Wati Jamir for the respondents number 4 and 5. Stop. Para. The brief fact of the case is that an accident occurred on 31/3/2021 at NH 61 under Wokha district involving a vehicle. What vehicle was it?
Bolero.
A Bolero vehicle bearing registration number NL 07-9947, where the claimant's husband, a pastor by profession, succumbed to the injuries on the spot. Stop. During the accident, the vehicle was driven by a paid driver and the deceased was seated on the back seat along with his mother. Stop. The fact about the accident was duly reported to the Wokha police station, Wokha, Nagaland, which was registered as GD number 002/21 of Wokha PS case number 009/2021. Stop. Para. The claimant / respondent filed the claim petition under section 166 of the MV Act before the learned MSCT Dimapur, praying for compensation against the opposite parties. Stop. Para. Upon consideration of the pleadings and after adducing evidence, the learned tribunal awarded a sum of rupees 15 lakhs as compensation, along with interest at 7.5% per annum from the date of filing of the claim petition until realization, to be paid by the appellant / Oriental Insurance Company Limited within a period of 30 days from the date of the order. Stop. Being aggrieved by the impugned judgment and award dated 19/6/2025, passed in MEC case number 54/2021, the appellant/insurer has come before this court challenging the judgment on the following grounds. Number 1. That Section 166 of the MV Act can be resorted to only by the third party, only for the third party. Stop. In the present case, the deceased was the owner, and the vehicle was being driven by a paid driver. And therefore, the trial court could not have entertained the petition under Section 166 of the MV Act. Stop. Number 2. It is stated that the investigating authorities failed to comply with the provisions of law, and no post-mortem examination was conducted by the investigating agency, and therefore it was difficult to ascertain the exact cause of the death without the post-mortem report. So, however, the claimant had failed to produce the same, and the tribunal should have taken notice of this fact. Stop. Next, number 2. It is also submitted by the learned counsel for the appellant that the sum assured. Okay, in that, now you just say on this point, the learned counsel relies on the case of Gohar Muhammad. And you just take this later. Okay? Gohar Muhammad versus UP State Road Transport Corporation and others in civil appeal number 9322 of 2022. Then next, learned counsel for the appellant also submits that the sum assured in the personal accidental death of owner driver is a fixed amount of rupees 15 lakhs as per the policy. As per the policy, which was a private car liability only policy -zone B. Stop. It is submitted that the tribunal also noted about the instant case not being a third party claim, but failed to decide the matter as per legal procedure. Stop. It is also submitted that the tribunal erred in law by passing the judgment against the insurance company along with excessive interest of 7.5% from the date of filing, and that the interest should not be applicable in the present case, as the premium amount coverage is fixed at 15 lakhs, and moreover, since the present claim was not a third party claim, the tribunal could not have passed the said award in the present case. That's all.
Yes,
Then, hence, learned counsel for the appellant raised that the impugned judgment and award dated 19/6/2025, passed in MSC case number 54 of 2021, may be quashed and set aside. Stop. Para. Learned counsel for the respondent claimant number 1, 2, and 3, Mr. Pendangobang, has submitted that the present petition is not maintainable in as much as, what is that? Why not maintainable?
Concerning with the ground set forth, ground that they have set
In
forth.
as much as the grounds set out by the appellants are not valid grounds for appeal. It is also stated that, it is also submitted that the learned tribunal, it is also submitted that the insurance policy clearly shows that the insured was the pastor Poro Lengri Out Baptist Arogo. Stop. And the additional premium has been paid for owner driver. Stop. Learned counsel also submits that the factum of the accident as well as the death of the deceased has not been disputed by the insurer before the learned tribunal. Stop. Learned counsel further submits that the deceased was travelling in his own vehicle, not in the capacity of passenger, but as an occupant. Stop. However, there is no legal bar under a contract of insurance that the owner cannot travel in the vehicle along with a paid driver.
My lord, not as a occupant, I am saying that it was the owner. If just one sentence, occupant, it seems that.
Which previous sentence?
Yes.
Just read out once. Own vehicle.
As owner, not as occupant.
Oh, as owner.
Yes, owner.
As owner, yes. As owner. Okay, then that's not forbidden, that there's no, that owner cannot travel in the vehicle along with a paid driver. Nah? He has also submitted that the appellant / insurer has also admitted in their has also admitted before the tribunal, as well as in their appeal, as well as in their pleadings in the appeal memo, that the sum assured in personal accidental death of owner driver is fixed at the amount of rupees 15 lakhs. Stop. Then what was the other ground?
The finding arrived by the tribunal. There is nothing wrong.
Learned counsel further submits that there is no rider. You said that also, that there is no rider in the policy that only the driver shall drive the vehicle, and that while the vehicle was being used, only the owner could drive the vehicle. Stop. It is not disputed that the registered owner is the pastor Boro Lingri Baptist Aroko. And as such, in order to cover up the additional risk of insurance, an additional premium for owner driver to the tune of rupees 320 had been paid. And as such, the vehicle could be driven by the owner driver or by its official driver or by any other person entitled to drive the vehicle with proper driving license. Stop. Accordingly, it is prayed that this court may not interfere with the ensuing judgment and award, as the learned tribunal has come to the correct finding that the claimant respondents are entitled to compensation of rupees 15 lakhs along with interest at 7.5% per annum from the date of filing of the claim petition. Stop. It is further submitted that the amount of interest is also rightly given as the interest amount is the discretion of the tribunal. Stop. Para. The court has considered the submissions of the learned counsel and has also perused the pleadings of the parties. Stop. The court has also gone through the trial court records in original. Stop. Para. Okay, I'll just go through the records and finish it, okay? Otherwise, I'm dismissing it. We'll continue.
Your Lordship,
Yes.
My lord, just to highlight one fix. While admitting this petition, appeal, in I was passed, wherein the court has given a direction to the opposite party to deposit 50%, which is, as per the report, which is not complied by the insurer also. So that is not the ground that I'm trying to bring it out. But when the award has not been deposited before the trial court nor at any place, and as per the direction of this honorable court order, I would brief before this honorable court that the amount as per the order as passed by the learned court below has to be complied at the within a limited period. That is what I.
You did not deposit the 50%.
No,
not
as per
yet,
the
Your
report.
Lordship.
Three months.
Yes,
3 months will do.
Your
3 months
Lordship,
is okay.
For me, if the court permits, 1 month it will be sufficient because
Your Lordship, as per the
No, if
previous
they are unable to pay even that 50%, 2 months.
previous order, we have already informed the company to send it, but there is some procedure, so it takes time, Your Lordship. So 2 months will do.
2 months, okay, 2 months.
Your Lordship, if in the order it may be reflected to allow us to withdraw the 25,000 statutory fee which have been given during the time of filing.
Goes without you, yes.
Obliged, Your Lordship.
For admission, item number 8.
Send it to the chamber.
May I please, Your Lordship?
Yes.
I've received an instruction this matter is for the appointment under compassionate scheme. Now here the petitioner have been listed in number 2. The department have sent to the government for the approval.
Okay, already forwarded.
Lordship.
Serial number 2.
Yes, Lordship.
Then we'll dispose it.
Yes, Lordship. Lordship, finally, after filing the petition, the respondent forwarded
At
my
least-
name.
at least they have-
Otherwise, I'm waiting since 2014. My file expired in the year 2014. And despite vacancies, my case was not considered. Therefore, Lordship, in view of this letter, however, Lordship, you kindly see
No,
on remarks column. My case has been-
Retiring on 31/12.
Yes, next
So,
month.
Next month.
So a time
immediately
frame,
after-
yeah, time frame will be given within 2 months,
Yes,
3 months.
yes,
Lordship.
yes. Heard learned counsel for the petitioner, Mr. Wati Jamir, as well as Mr. Achumni Sanktam for the state respondents. Stop. Para. The present petition under Article 226 of the Constitution of India has been filed by the petitioner seeking appointment on compassionate ground. Stop. Para. The case of the petitioner is that the petitioner's father, died in harness on 10/12/2014.
Lordship, it should be 12/10, Lordship. It's
Oh,
certificate
okay,
21.
On 12/10/2014, but in your synopsis you have written 10/12. On 10/12/2014, while serving as assistant mechanical engineer under the establishment of the mechanical department, PWD, Nagaland, leaving behind 4 school-going children. Stop. After the death of his father, the petitioner submitted an application for appointment on compassionate ground in the year 2014 and again on 8/8/2017. Stop. However, failing to get any response, the petitioner filed RTI.
Yes, Lordship.
The petitioner filed an RTI
On several questions I
application-
filed earlier.
filed an RTI application in the year 2022 with regard to the list maintained by the department for compassionate appointment and the appointments made thereupon. Stop. As per the information received, other persons who had died, whose parents had died after the death of the petitioner's father, were already appointed on compassionate ground. Stop. Learned counsel for the petitioner submits that as per the scheme for compassionate appointment, scheme dated page, scheme for compassionate appointment,
Page 24.
number compassionate appointment being office memorandum number AR-8/8/78 dated 17 September 2015. The appointment on compassionate ground should be made up to 50% of the direct recruitment vacancy during a year. However, the respondents have not been adhering to the scheme for compassionate appointment. Stop. Till date, the petitioner has not been appointed even after a lapse of, how many years is that? 15, 16, 17, 18, 19, 20. 9 years. Even after a lapse of 9 years. So, being aggrieved, the petitioner has approached this court, praying for a direction to the authorities to consider the petitioner's case for compassionate appointment in terms of the OM dated 17/9/2015. Stop. Para. During the course of hearing, stop. The learned counsel, the learned government advocate, Mr. Achumni Sanktam, has produced a copy of the letter number CE/M/PW/EST 26/2015 dated 13th October 2025, by which the Additional Chief Engineer, PWD Mechanical, Nagaland, has forwarded the name of the petitioner to the government for appointment on compassionate ground against the vacancy created by the retirement of one Sri Salu Angami, SALU, Salu Angami, under bracket, you write PWD 13731, close bracket, welder, 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 retiring on 31/12/2025 under AME Kohima, AME, capital AME Kohima. Stop. In view of the letter dated 13/10/2025, comma, this petition is disposed of with a direction to the respondents number
Respondent number two.
2 and 3, no? Respondent number 2, 3 and 4 to
Approval will be granted by respondent number two.
respondent number 2.
Once the approval is complete, Lordship,
Yes.
appointment will be issued by
Will be
respondent number
issued
four.
by respondent 4, isn't it? So we'll just say 2, 3 and 4.
Yes, Lordship.
To the respondents 2, 3 and 4 to appoint the petitioner in terms of the proposal dated 13/10/2025 against the vacancy created by one Sri Salu Angami, retiring on 31/12/2025 within a period of 2 months.
No, Lordship, it's too short, so at least minimum it should be 6 months.
No,
Lordship.
he's retiring on 31/12.
The next month, Lordship.
But
It is on record.
So immediately,
After 2 months, Lordship.
yeah, after 2 months they can do it. So 3 months then, within a period of.
If there is any delay, then Lordship, the petitioner will be overreached. That is the problem facing. By next year, the petitioner will be overreached.
Within, or we'll say within 1 month.
No,
Within
Lordship.
1 month from
After
the
the
date of his
retirement.
retirement.
Lordship.
Okay.
at least.
Proposal is
3
already
months.
there.
Yes, Lordship, but still then,
But it has to go to PNR again.
Lordship.
Because
they-
compassionate
they have to
appointment, it
take-
always
Then
goes
3 months,
to.
Lordship, from date of order.
Okay,
6
within a
months is
period-
much
no,
appropriate
no,
for.
that is too much. Within a period of 3 months from the date of this order. Yes, that will do.
Oblige.
The above directions, the petition stands disposed. Yes.
For admission, item number 10.
It is in order.
Yes.
Lordship, so as per the previous honorable court's, this honorable court's order dated 28/8/2025, the appellant was directed to take steps upon the respondent number 8 and 9 by paper publication, substitute to which we have taken steps and we have filed our affidavit of service, Your Lordship.
You filed.
Yes, Lordship.
When was it published?
4/10/2025.
4/10.
Yes.
Learned counsel for the appellant, Mr. Medovero, is present. Stop. The appellant has filed the affidavit of compliance regarding notice on the respondent number 8 and 9 by publication in the
Assam Tribune.
no, when was it published? That date?
Both are 4/10.
Okay, published on, the publication in the 4th October issue of the Assam Tribune and the 4th October issue of the Murung Express. Stop. None appears for the respondent number 8 and 9 when the matter is called. Stop. Accordingly, the notice on respondent number 8 and 9 is deemed served. So, learned counsel, Mr. Sarif Ahmed appears for respondent number 1 to 7 and Mr. K. Angami for respondent number
11.
11. Stop. So now, notice is all complete.
Lordship.
Notices are complete.
Then I think it's not complete.
What about
I've,
who is responding to?
Dong Shang Pom, Lordship, driver of Home Department.
I think driver, not a necessary party, maybe, if claimants are all represented. Are you filing any objections, respondents?
I'm here to receive instructions, so.
Lordship, I'll just object verbally. I'll not file any written. So I have some decisions to be given. So in the next date may be given so that I can physically appear before your honorable court and then I can submit some judgments with regard to condemnation of delay.
Oh, this is continuation of delay.
Lordship.
Lordship.
How many days?
79 days only, Lordship.
79 days.
Lordship.
79 days we will condone.
They need to show some sufficient cause, Lordship, because the statute says that it is 90 days. So when they are coming for taking the shelter of Limitation Act, they need to show some sufficient cause. I have some judgment passed by the High Court as well as the Supreme Court. So if a next date can be given so that I can physically present before Lordship and submit, Lordship. And the rest is a discussion of the court, Lordship.
Judgments, there are many judgments, but then again, it depends on the facts and circumstances of each case.
Correct.
You want to hear another day?
If your Lordship allows. Otherwise, it's up to the Lordship.
I think we'll just condone this. Okay, let us see. Stop. Then, yes. The present application has been filed under Section 5 of the Indian Limitation Act, bring for condonation of delay of 79 days in preferring the accompanying MSC appeal. Stop. MSC appeal number 10 of 2025. Stop. The main reasons for the delay have been set out at paragraphs. Let's see, what are your grounds?
Paragraph 7, Your Lordship.
At paragraph 7 of the application.
Lordship.
Stop.
Lordship, with your permission, with regard to paragraph 7, if your Lordship can come to clause C, Lordship can see, after passing of the judgment, they are appointing the investigator to investigate into the case. After passing of the judgment by the tribunal, Lordship. Whether these are sufficient ground for them, these are the sufficient cause. That's my objection, that's it.
Lordship, that is up to the insurance company, Lordship, whether they want to investigate more or not, Lordship, regarding the case.
No, investigation.
No.
It's not after the award. How can that be after?
Yes, Lordship.
Lordship, just 3 days, Lordship.
How many days did he take? 3 days.
Lordship.
3 to 6.
Yes. So that's all, Your Lordship. The main reason is para number D, Lordship, subpara, the 64 VB clearance, which is a premium which is to be paid while getting the insurance policy. So since the case is pertaining to 2005 cases, if Your Lordship, if I may be allowed to read para number D and E, Your Lordship, subpara D. Date on
Legal help communicated. What is this 64 VB clearance?
This is a premium, Lordship, that is to be paid while availing the insurance policy. A premium which is mandatory to be paid.
What did I say? Had been set out at paragraph 7 of the application. Na? Stop. The court has perused the same and is of the view that sufficient ground has been set out for the delay of 79 days. Stop. Accordingly, the application is allowed and the delay of 79 days is condoned. Stop. Then say in the main appeal. Na? Records have been called in the main appeal, not yet, no?
Not yet, Lordship.
Yes. The present application is an appeal under Section 173 of the MV Act 1988 against the impugned judgment and order dated 6/1/2025 passed by the learned MSCT Dimapur in MSC case number 17 of 2015. Stop. The appeal is admitted. Stop. Call for the trial court records from the Motor Accident Claims Tribunal, Dimapur. Stop. Learned Counsel, Mr. Medo Vero appears for the appellant. Stop. Mr. Sharif Amit appears for the claimant respondents. And Mr. K. Angami appears for the respondent number 11. Stop. List after a month. No?
Lordship.
List after a month. Registration. Did I say direction to call for the records?
Yes.
Okay. List after a month on a date to be fixed by the registry.
Much obliged, Lordship.
Item number.
Highly obliged.
From which one? Just check it out. Yes.
Lordship, here I'm yet to file affidavit in opposition. I'm appearing for respondent number 7.
Number 7. Respondent 8 also has not filed. Who is respondent 8?
Union, Your Lordship, represented by Mr. Yangawati, Your Lordship. And 9 and 10 is the railways. It is represented by Mr. YP Gupta. So all the parties are represented, Your Lordship.
9 and 10, YP Gupta appearing.
Yes, Your Lordship.
And 8 is
Mr. Yangawati. Yes, Your Lordship.
And you. Learned Counsel for the petitioner, Ms. Esther is present. Stop. Learned Counsel, Mr. I forget your name.
Aliba
Uzakam, appearing for respondent number 7. Prays for some time to file his affidavit in opposition. So you have also filed? Not yet. Learned Government Advocate, Mr. V. Jamomi, also has similar prayer. Stop. Learned CGC, Mr. Yangawati, has entered appearance for respondent number 9 and 10. Na?
Respondent number 8.
Oh, respondent number 8.
And for 9 and 10, Mr. YP Gupta.
And they are yet to file their affidavit. Stop. Respondent number 9 and 10 is represented by Mr. YP Gupta. Stop. Accordingly, list the matter after 3 weeks in order to enable the respondents to file their affidavit in opposition.
Much obliged. This is interim, Your Lordship.
Oh, the interim order passed earlier shall continue till the next date.
Much obliged.
For hearing, item numbers 12 and 13.
My Lord, WPC 241 is, I'm demanding for a CPA inquiry.
Oh, acha, that case.
My Lord.
Acha, just give me CRPC. Magisterial inquiry, just check out magisterial inquiry in custodial debt.
176.4.
176, no? 128. See, when a magisterial inquiry is conducted, normally cross-examination is also allowed. And relatives of the deceased are allowed to cross-examine. So I feel that a fresh inquiry needs to be conducted, allowing the petitioners to also cross-examine. So we'll give that direction, okay?
Your Lordship, by the direction of this Honorable Court, there was an inquiry report, Your Lordship.
Yes, but they were not given opportunity to cross-examine the witnesses.
Your Lordship, now the petitioner is actually stating that it should be covered by the commission under commission inquiry. Your Lordship, if you can kindly come to that. Your Lordship has already given me actually direction to have a look on it, Your Lordship. The commission inquiry report, Your Lordship. They are saying that as per the Commission Inquiry Act 1952, clause
8C. 8C.
Yes, clause 8C. 8C, they have the right to be examined, Your Lordship. Now, we have to see how the commission of inquiry is to be done, Your Lordship. It has to be done, the commission has to be set up by way of a notification, and after that, in that provision, yes, that can be examined. But here, the court has given a direction for fact-finding. So according to the fact-finding, Your Lordship, all the people who are witnesses, they were called on a different date, and they were examined. And on taking all the facts, all the relevant examination, like this was forwarded to this Honorable Court. Now this Honorable Court can peruse this inquiry report, and if unsatisfied, then, Your Lord, why attack inquiries?
The court has gone through, that's why I'm saying that they were not given the opportunity to be cross-examined, to cross-examine the witnesses.
Your Lordship, that
Because
is
at this stage, I feel re-investigation by CBI also would be, Ms. Bentang was just here, would be a futile exercise. Because after so many years, what evidence can they find? What evidence can they find at this stage?
My simple submission, very limited submission in this case. I'm not inclining on either side. Here, only the court has to see whether it was a custodial debt. It will be of any nature.
Yes.
So, in this particular case, the death occurs within the perimeter of the police station.
Yes, police station.
So, when the death has been established, in my limited ground, my submission is confined particularly to writ petition 241, where CBI was been implemented as a party, in this case, as respondent number 8, to go for further investigation by the petitioner. My submission is that what the court, this Honorable Court has observed is very much correct. Now, when the factum of the death has been established within the perimeter of the police station or other lockup, Now the negligence is on the part of either on the part of the prosecution side, otherwise the police that they have not meant the duty in proper good spirit. That is the only submission. So to exercise a further investigation by the CBI or any other agency, it will be a futile exercise. So I say that the CBI should be deleted from the area of the party if the matter has to be go ahead.
Because this is a case which happened in 2016.
16.
Now it is.
In the writ petition is pending since 16.
No, but still then, the offense also happened in 2016.
My
So
lord.
what evidence can we get now?
My lord, I understand my learned friend's submission because it is in a very rare case only.
So, like he said, the factum of death, it is not disputed. The only thing is to pin the responsibility, who was responsible,
Now, Your
the
Lordship,
negligence part.
Your Lordship, I have one submission here. Your Lordship,
And then our
as-
necessary compensation,
Yes.
that's all.
As far as like the petition of the petitioner is concerned, Your Lordship, all averments from the para 1 till the last, Your Lord, till the prayer, it's all about the torture being meted out. Now we have to firstly ascertain whether torture has been meted out to the accused or not, to the deceased or not, Your Lordship. We have to ascertain because all of the petition is based on the torture being meted out, and because of the torture, the custodial death. Okay, this lordship can go to the extent of civil liability. Okay, whether there was a negligence or not. Okay, that part, yes, as per the law permits, that can be looked into. However, Your Lordship, when we see the petition of the petitioner, Your Lordship, it's all about the torture being meted out, and nowhere in the records it says that torture has been meted out. No evidence, Your Lordship. So I'm concerned only to that, confined to that part only. Now, how will that be? That can be brought up. That is my question. That is my submission. Because all of the petition is all about torture being meted out, and because of the torture in the police custody, Your Lordship,
My lord,
he has been
my lord,
succumbed to death.
I mean,
What is this amicus? Amicus was also appointed.
there
yes,
was
because
a amicus curiae appointed by the court.
For what?
Yes, Your Lordship. What happened is that we have been
mostly
having
to
a
assist
lengthy
Your
discussion,
Lordship.
Your Lordship. On many occasions we had a discussion and the court has come to a final decision. Okay, there's some negligence. That's why we will award a civil liability. And therefore the court came to a conclusion that a civil liability will be awarded. Then, meantime, I brought to this court notice because in order to prevent duplicate payment, I brought to this lordship that Human Rights has also commissioned 5 lakhs. And on that virtue, the court was about to pass order, but on that thing, the petitioner said he wanted to seek a clarification or advice from the petitioner, and that is how this case was prolonged. And amicus curiae was also appointed so that at least some
My lord,
conclusion can be
I
brought
object
up.
to my learned friend's submission. No. This is a situation where the petitioner is totally in the dark. I just want an inquiry.
Okay, see, the amicus has submitted a report.
Yes, Your Lordship.
Where he says that the finding of the inquiry officer that there was no suspicion and evidence of any foul play appears to be a finding based on conjecture and surmises.
My lord.
It also reflects non-application of mind. So when nobody is cross-examined, then nothing will come out.
Your Lordship, that is up to the mind of this
I
court, Your
think
Lordship.
fresh inquiry is required in this case.
The fresh inquiry is by the district and session
Yes,
judge,
yes, by the district and session.
then maybe a different district and session judge.
My lord, now it is a different
Now it's a
district.
different
Yes,
session judge.
because earlier also
And
we...
will also give specific direction that the witnesses should be allowed to be
My lord.
cross-examined by the petitioner.
Just if that has to be brought on the for the judicious
Because
conclusion,
something
then
has
no
to come
problem,
out.
Your Lordship.
Something has to come out, and just recording their statements alone will not reveal anything.
Your Lordship.
Okay. Let's
Lordship,
see.
in
Oh,
confining
it's
to
time.
241.
We'll pass order at 2, okay?
My lord.
Confining to 241, if my name, the party has been delayed from the area, that would be more appropriate. Because
My lord, it is by a judicial order. Let it be there.
Let it be there.
My lord.
We'll see what direction
But-
will be passed later. We'll see.
Much obliged.
By which order the inquiry was directed? Order date.
It is reflected in the
4/6,
inquiry report.
2024. 4/6, 2024. It was submitted on 11/11.
Oh, 6/2024, and report was submitted on
11/11,
11/11/2024. Learned counsel for the petitioner, Mr. Inti Longchar is present. Learned government advocate, Ms. Livika, appears for the state respondents. And Mr. Pendang Wabang is present for the respondent number 8/CBI. Stop. Yeah. The present writ petition has been filed by the petitioner seeking a direction against the respondent authorities to register, conduct and complete a proper investigation in respect of the petitioner's late brother's death, who died in the lockup of South Police Station, Kohima, Nagaland on 30/10/2016. Stop. A prayer has also been
My
made.
lord, the date of date is, they've given us 29/10/2016.
No, I'm just going by your writ petition where you have
lord.
stated 30/10. Okay, 29/10/2016. Stop.
Actually, if you go by that, it's 30 because he died on 30th morning.
In your petition also is 30/10.
My lord, yes, I reach on 30/10.
No, you have stated in your petition, see, para 2, late brother who died on 30/10/2016.
My lord.
So we'll go by that,
My lord.
30/10/2016. So a prayer has also been made for referring the matter to the Central Bureau of Investigation for conducting a fresh investigation. Stop. And also for a direction to institute a commission to oversee the investigation to be carried out. Stop. During the pendency of the writ petition, this court, by order dated 4/6/2024, had directed the District Judge Kohima to carry out a fact-finding inquiry as regards the death of late Jalaluddin,
My lord.
Jalaluddin, late Jalaluddin, and to submit the report before this court within 3 months from the date of receipt. Stop. The Superintendent of Police Kohima, as well as the officer in charge of the South Police Station Kohima, were directed to provide necessary assistance to the learned District Judge Kohima for conducting the said inquiry. Stop. It was further directed that the learned District Judge Kohima shall conduct the said inquiry with the powers of a commission in terms with Commission of Inquiries Act 1952.
Your Lordship, whether that can be permissible, because if we go by Inquiry Commission Act of 19, the government has to issue a notification. It is an executive tool, it is not a judicial tool, Your Lordship. So if this Honorable Court deems that inquiry should be...
No, what the court meant was the procedural aspect.
Okay,
to
okay.
conduct
Otherwise,
as in the not exactly a commission of inquiry, but the procedure to be followed.
okay, otherwise to that cannot be applied because
Officially,
notification,
yes,
it
yes,
should be by a
notification has to
official
be
gazette.
issued. Yes. What did I say? To conduct the inquiry with the due powers of a commission in terms of the Commission of Inquiries Act 1952. So, thereafter, the inquiry report was submitted by the Learned District Judge Kohima on 11/11/2024. So, the Learned Counsel for the petitioner submits that. Acha, where is that you had submitted that Commission of Inquiries extract, na?
In my written argument,
Oh, in your
written submission, 7/10 of 2025.
Section 8C, isn't it?
My lord.
After, what did I say? After going through, the Learned Counsel for the petitioner submits that upon going through the, submits that the fact-finding inquiry by the Learned District Judge Kohima was not conducted as per the procedure laid down in the Commissions of Inquiry Act 1952. Stop. Learned Counsel submits that as per Section 8C of the Commissions of Inquiry Act 1952, the petitioner had to be given the right of cross-examination and representation by legal practitioner, and the commission should have allowed the petitioner to cross-examine the witnesses. Stop. He submits that even after, even in Section 176, Clause 4 of the CRPC, when a magisterial inquiry is conducted, the magistrate is under an obligation to inform the relatives of the deceased, whose names and addresses are known, and shall allow them to remain present at the inquiry. Stop. It is the submission of the Learned Counsel for the petitioner that the inquiry was conducted in the office chamber of the District Judge Kohima without the presence of the petitioner's family, without the presence of the deceased family or the petitioner's counsel, except on 21/8/2024 and 27/8/2024, when the family of late Jalaluddin were examined, that too without the presence of their counsel. The court has perused the inquiry report submitted by the Principal District Judge Kohima on 11/11/2024 in compliance with the order of this court dated 4/6/2024. Stop. Upon examination, it is observed that the learned principal district judge has only recorded the statements of all the witnesses and had come to a finding.
Some of the witnesses have died.
Yes, some of the witnesses, because they are saying that one Vinod Lama have filed a FIR against the deceased. He was not examined, not even called.
Okay, okay.
So that should be the beginning.
So only some were examined?
Yes.
I think two has already died. The witnesses who were there at the time of commission of the I think
already died.
so their examination too, it's impossible to take. The rest it has been taken.
Only some of the witnesses had been examined, and the petitioner was not given an opportunity to cross-examine the witnesses.
Four of them, four.
Only four were examined.
Four died.
Or you can say only for some, no? Just say only four of the witnesses. And the petitioner was not given an opportunity to cross-examine the witnesses. Stop.
My lord.
Actually, it doesn't mean that only those PWs should be examined.
No.
It's okay, well,
No.
It's
whoever
up
is
to the
required.
inquiry officer.
Inquiry
Whoever
officer.
My
they
lord.
feel,
Whoever they-
yes, whoever they feel is able to give some
My
information.
lord.
Yes, exactly.
Yes, that can also be called actually.
Yeah, no problem.
Yes. In in the opinion of this court, a fresh inquiry needs to be conducted in the interest of justice so as to allow the petitioner to cross-examine all the relevant witnesses.
I think doctor's examination should be mandatory, Your Lordship.
Doctor, yes.
The one who has done the postmortem.
Stop. Next para. Or you just continue. Accordingly, the Principal District Judge Kohima is directed to conduct an inquiry, fresh inquiry, with regard to the death of late Jalaluddin by summoning not only the prosecution witnesses who have been recorded in the case records, but also all relevant witnesses who would be able to provide information on the death of late Jalaluddin, including the doctor who conducted the postmortem.
My lord.
Doctor is
And
already examined.
as well as the informant.
Informant.
Informant was never
Okay.
examined.
As well as who is the informant? As well as
They are saying to be one Vinod Lama.
informant / Vinod Lama. His name is there in the records.
My lord.
FIR. Okay. Informant
Page
/
52.
Vinod Lama. Okay. Stop.
This is not the person who filed the FIR against the deceased. Against the deceased. They are saying that one Vinod Lama
No,
filed a
since you'll be
FIR.
appearing before the district judge,
My lord.
you can give the names because they will be allowed to give your names
My lord.
as witnesses.
My
So
lord.
that time also you can provide.
My lord.
Okay. To carry out such and such and submit the report before this court within 3 months from the date of receipt of this order. Stop. The learned district judge, principal district judge Kohima shall also allow the petitioner / petitioner's counsel to cross-examine the witnesses in terms of the procedure under the Commissions of Inquiry Act 1952.
Your Lordship, my humble suggestion, Your Lordship, it would be good if you will not quote the commission, because
Okay,
commission is
shall also then-
specifically
My lord.
Also
let
allow
it be
the-
the judicial order, specifically judicial.
Don't put the Commissions of Inquiry.
Yes.
Shall also allow the petitioner / petitioner's counsel to cross-examine the witnesses. Okay, stop. The registry is directed to send a copy of the order, of this order, as well as all relevant documents. What will be the relevant documents required?
Your Lordship, it will be better if the police concerned, the superintendent, all this thing, provide the relevant documents and be present before the district and session judge, just as the last order. Because here too, we have only the copy which was furnished to the original records will be brought by them.
Okay, then registry will only send the copy of this order to the learned principal district judge. Stop. The
SP may be directed to cooperate.
the superintendent of police Kohima, as well as the officer in charge of the South PS,
Yes.
South PS Kohima, are directed to provide all the necessary documents to the learned principal district judge and also assist the inquiry officer in order to conduct the said inquiry successfully. Stop. And what else?
Your Lordship, one more thing. The petitioner counsel has actually objected that the magistrate himself has not visited the place of occurrence. Let the district and session judge also visit that place, because on that ground only
My
he was
lord,
objected.
that is the amicus curiae.
No, not
They were
necessary
objecting on
actually,
that
not
also.
necessary. At this point, after 9 years, even if you visit, what will you see?
They were stating last time that the district and session judge has not physically.
My lord,
present also,
this,
no? So all those things-
submission, I'm very sorry. This is not my, never my submission.
That was the amicus they're saying.
This is the amicus curiae.
Amicus,
Yes.
No, is there any issue like whether like they made it seem like a suicide and hanging and all that? If that is the case, then maybe the place will have to be inspected. Is there any allegation?
Just to overcome all the flaws.
In
My
the
suggestion, because they were objecting last
argument,
time.
in one way or the other, there was a suicide also concerning, because as per the affidavit filed by the state respondent, it was a suicide.
That's what I'm saying.
Suicide.
Hanging.
Yeah, hanging. Hanging on the grill.
That is their version.
That is the version of the.
That
Yes.
is our version. The
But
version
still
is
then,
torture.
if that version is there, then the site has to be inspected to see
My
whether
lord.
the learned principal district judge Kohima shall also inspect the place of occurrence in order to assess, or you can say shall also visit the place of occurrence in view of the fact that the state respondents in their affidavit have made the allegation that it was a suicide by hanging, isn't it? Suicide by hanging. Stop. Para. You don't need a copy, no? Do you also need?
Your Lordship, if a direction is sent, then
Yeah, that will be
okay.
sent. Okay, stop. List again on expiry of 3 months, or you can say on submission of after submission of the report by the learned principal district judge.
And my lord, there is another writ petition connection to this, 120 of 17. That is for compensation. As per
No,
my,
this will be dependent on the report.
my lord, yes, I understand that. But in the meantime, there is a Human Rights Commission direction to the state for payment of 5 lakhs. Will it be okay for your lordship to direct the state respondent to make the payment in 120 of 17?
That is not the direction of this court. That is the direction of the
National Human Rights. Yes,
Commission.
I understand
so
that.
They will have to direct.
My lord.
This one will be kept pending
Yes,
till
Your
the
Lordship.
disposal.
And there
till the
cannot be a
report.
duplicacy of payment, Your Lordship, for the same cause. I have a ruling citation on that, Your Lordship.
That
So
we'll
if
see
this
later.
court decides
That
should
point
be
we
above
will
5
decide
lakhs,
later.
yes,
Yes.
that will be
Let
decided
the
on
report come,
facts
and
of
if the court finds that there is some foul play,
Yes, yes.
then compensation will be awarded.
Yes, right.
But depends.
Much obliged.
For hearing, item number 14.
Criminal appeal.
May I please, Your Lordship? Your Lordship, this is a case related to NDPS Act, and the appellant has referred this criminal appeal against conviction that was passed by the District and Session Judge Peck. Your Honor, the present case was tried before the Court of Special Judge Peck, and the accused was convicted under the NDPS Act on the 18th of March 2020. Your Honor, he was convicted for a term of 10 years rigorous imprisonment with a fine of rupees 1 lakh, and in default of the payment of the fine, the accused to undergo 1 year rigorous imprisonment. Your Honor, the brief fact, this present case, it arose from.
Now he has served for how many years? He was convicted on 18-3.
Yes, Your Honor. Your Honor, presently the accused person is on bail.
Oh,
Earlier we have filed a bail application and he is on bail. Your Honor, very briefly, the fact, the present case arose from alleged recovery and seizure of 50 kg of contraband ganja from a Maruti Alto 800 by the 14th Assam Rifled on 24th of June 2019 at around 9 p.m. on acting on prior information received. Now, Your Honor, coming to the reason for conviction, Your Honor, the special judge fact had convicted the accused person on the basis of Section 35 of the NDPS Act, that is presumption of culpable mental state. Your Honor, I'll go straightly to the grounds of my arrest. Conviction, Your Honor. Your Honor, my ground for a criminal appeal is confined solely on the violation of procedural mandates and the due process and requirements, Your Honor. Your Lordship, this present case, it suffers from gross violation of the mandatory requirement under Section 42 of the NDPS Act. Not only that, Your Lordship, this present case suffers from violation of Section 52 of the NDPS Act, Section 52 Clause A of the NDPS Act, Section 55 and 57 of the NDPS Act. Your Lordship, the entire case is a basis of prior information received by the 14th Assam Rifle, where strict compliance to the due process of law under Section 42 of the NDPS is very much required, Your Lordship. However, it is evident from the record that the mandatory requirements were not complied with, and this vitiates
Reporting to superior officer.
Yes, Your Lordship. And this vitiates the entire process. Your Lordship, the 14th Assam Rifle, on seizing the contraband substance, they did not inform, and only the incident happened on 24th. The recovery happened on 24th of June. And only on, as per the report, they have produced the recovery on 25. But as per the seizure memo, Your Lordship, they have handed over this contraband substance to the police only on 28, that is after a lapse of 5 days. After a lapse of 5 days.
24th was the date
of recovery.
24/6/19.
Yes, Your Lordship.
19 recovery.
Yes. FIR was filed on 25, Your Lordship.
FIR on 25.
And then seizure memo, handing and taking of the contraband substance was on 28/6.
Over on 28/6.
Yes, Your Lordship. And Your Lordship, I must praise to submit that these two mandatory procedural requirements that are laid under 42. One, the information must be reduced to writing under 42 Clause 1 of NDPS Act. And two, the written information must be forwarded to the immediate official superior under 42 Clause 2 of the NDPS Act. This should be followed. But, Your Lordship, this was vehemently violated. Your Lordship, earlier, the law mandates that information taken in writing by an empowered officer, it must be sent forthwith to his immediate superior.
What about the seizure? Seizure was made by empowered officer.
Seizure was, Your Lordship, as per the documents.
Who made the seizure?
Seizure was made by the complainant, Your Lordship.
Who is the complainant?
Seizure memo, D.D. Joshi.
That is the problem. Because the empowerment of Assam Rifles to make seizure, when was that passed? Because earlier they were not empowered, Assam Rifle. Okay.
Your Lordship.
2000, only in the sometime in the year 2021 or 22, I think that notification came out empowering the Assam Rifles as empowered officer. IO and above, I mean SI and above. Because if this seizure is before that notification, then the entire seizure is vitiated. Assam Rifles cannot make seizure. It is only the SI and above of either excise or police. You don't have that copy, no? Assam, you also don't have.
No, Your Lordship.
Otherwise, that will be your major ground actually. If this seizure is made before that empowerment. Anyway, let us see your other grounds.
Okay, Your Lordship. Your Lordship, to be continued.
Yes.
Earlier, there was no specific time prescribed. However, after the Amendment Act 9 of 2001, within 72 hours, time bond was inserted. Yet, despite this being vested with full prescribed time limit of 72 hours window period, it is evident enough that the arresting party or the police, they have not acted in accordance with the law, nor has offered any reasonable justification for this glaring omission, Your Lordship, neither initially or within the grace period of 72 mandatory of 72 hours, even after.
72 hours to produce the seized article? Or 72 hours?
72 hours.
Just give me NTPS Act.
Earlier, Your Lordship, that written information, if in case
written
of
information, in case
urgency.
of prior information.
Yes, yes. If there is urgency arises, which is likely that the accused 72 hours grace period is given, window period is given. But even after that also, even after post-recovery also, Section 42 has not been complied with in this present case, Your Lordship.
Where an officer takes down any information in writing under subsequent search, he shall within 72 hours send a copy to his immediate official superior. Okay.
This was also not complied with, Your Lordship. Your Lordship, another ground, drawal of sample, Your Lordship. Your Lordship, there is a material contradiction, even in the way the samples were taken from the seized contraband substance, and the identities of the samples drawn were not conclusively established. The testimony of the IO, Your Lordship, it contains clear mistakes and shows improper appreciation of facts, and this has raised serious doubts about the validity and reliability of the evidence presented. Your Honor, the IO, in the forwarding letter, sent for chemical examination, which is under page 59, Your Lordship.
59 of the paper book.
Yes, Your Lordship, of the paper book, annexure E59.
Forwarding of samples.
In this forwarding letter, Your Lordship, the IO has mentioned that the chemical examination, the sample sent for chemical examination, it consists of 3 samples. Sample 1 is 30 grams, sample 2 is 25 grams, and sample 3 is 15 grams. Now, another contradiction, Your Honor. There is another contradiction in the statement of the IO during trial, where he stated that samples of 30 grams each were drawn from the seized contraband ganja. Not only this, Your Lordship, there is another contradiction here.
Who stated?
The IO stated that 30 grams each were drawn from the seized contraband ganja. Now, Your Lordship, coming to FSL report again.
Regarding this also there is some discrepancy. According to the standing notification, when it is ganja, how much should be drawn for sample?
Sample is 24 grams, Your Lordship.
24 grams?
Yes, Your Lordship.
Then that also is... You're sure, 24 grams?
Yes, Your Lordship.
Do you have that standing notification? No, it's a different, it's not in the Act.
Okay.
It's a notification issued by the Ministry of Revenue.
Okay,
Saying
Your
that
Lordship.
if it's ganja, this much sample should be drawn. If it's chemicals like methamphetamine and all, so this much should be drawn like that. There's a, because NDP is such a technical act, no? You have to follow each step very carefully. That also someone should have produced actually. You also don't have, no? No.
Your Lordship, may I come to FSL report again?
Okay.
Here, in the FSL report, the seized ganja weight, it came out that in the report, the seized ganja, the samples are A, 27 grams, B, 26 grams, and C, 18 grams respectively, which is different from the weight earlier recorded. Yes, Your Lordship. Your Lordship, there exist serious variations, Your Lordship. The identity of the samples taken from the seized ganja was not conclusively established, and this prosecution has failed to build the foundational facts of the case, Your Lordship. And for this, Your Lordship, I must place reliance on the judgment of the Honorable Supreme Court in Union of India versus Mohanlal, which is decided on 28 January 2016, where the Apex Court has categorically laid down the mandatory procedures regarding seizure, sampling, and disposal of narcotic drugs in direct consonance with the mandate of Section 52A of the NDPS Act, as well as Standing Order Number 1 of 89 and notification dated 16 January 2015. Your Honor, Section 52A is primarily intended to ensure the safe custody, proper handling, and lawful disposal of seized narcotic drug and psychotropic substance. And the Apex Court has also emphasized that this section balances the state interest in early and severe disposal of narcotic with to preserve the legal sanctity of the seized material as primary evidence. Your Honor, this exists glaring contradiction in the role of sample, and each of the statement of the IO differs materially, and there is no cogent evidentiary basis to establish the exact procedure or number of the samples drawn, and this strikes the very roots of Section 52A, Clause 4 of the NDPS Act, which mandates that inventory, photographs, and list of sample under Section 52A, Clause 2, and certified by the magistrate shall be treated as primary evidence. Your Lordship, another serious matter, Your Lordship, here in this instant case, Your Lordship, as we go through the case records, there is no inventory list, Your Lordship. So, Your Lordship, not only as per the record, the recovery and seizure has taken place. However, it is very clear on record that the handing of seizure to the PS was done only on 28 after 5 days, which amounts to gross lapses and directly affect Section 52 of the NDPS Act. And nothing was done as prescribed and demanded by the law. Your Honor, the court has presumed culpable mental state against the accused person, but the prosecution initial burden to prove the foundational facts beyond reasonable doubt and has failed to prove beyond reasonable doubt. And not only that, the foundational facts are not proved, Your Lordship. Your Lordship, the sequence I've already apprised the court, but as per the sequence of the lapse of time factors. Your Lordship, time factors is very important when it comes to NTPS Act. But when you see this present case, from the initial till the last, the sequence of the lapse in the time factor can be seen. And this also, the chain of custody as well as proper seizure protocols, which are core requirements, this has all been violated, Your Lordship. There is no chain of custody.
From the time it was seized till production.
Yes, Your Lordship, yes. There has been, delayed factor has been observed all the time, but then there is no reasonable justification also. Your Lordship, these are my grounds. I'm basing on the procedural lapses, violations.
Yes. Difficult to defend.
Not much to say that. Well, let me put it in this way, that there's no infirmity in the judgment order passed, and that as pointed out in the paragraph 9, 10, 11 of the judgment and order passed in the pin order. So appropriate order may be passed.
In the first place, whether the Assam Rifles were empowered to search or not. That is the question. Because that notification, I will have to find out myself. Can you find it out? There's a notification where the Assam Rifles, starting from certain rank upwards, were empowered. I think if you Google it, you'll find it.
Okay,
I can also do some research, but why should the court do the research? Because only from that date onwards, the Assam Rifles were empowered. Okay, before that, they were not empowered to make any search or seizure in NTPS case. So, because I have acquitted many cases on that ground also, that the Assam Rifles were not empowered. But I think sometime in 2020, 21, I think they became empowered. But this is 19, isn't it?
Yes.
2019. So that itself, you just check out, and then if you find it, you just send a copy, okay?
Okay.
Then what else?
Your Lordship, I have annexed some of the Supreme Court cases, and even in this Honorable High Court has allowed criminal appeal on grounds of material contradictions.
And then, what is the other one? Which one do you have, Mohanlal?
42, in support of Section 42, I have annexed few of the Supreme Court judgment.
Oh, you have annexed in your appeal?
No,
in your
Your
memo?
Lordship. I have this.
Okay. Have you written the paras, relevant paras?
No, Your Lordship. I have just serially numbered it.
Have you marked?
No, Your Lordship.
Just mark the relevant paras.
Okay, Your Lordship.
I don't have time to read the whole judgment, so just mark
Okay,
the
Your
relevant
Lordship.
paras and send it over.
I'll
And
do
then,
that, Your
And
Lordship.
then that empowerment of Assam Rifles also.
Yes, Your Lordship.
Let's go. And then that standing notification also regarding sampling, no?
Yes, Your Lordship.
Certain amounts have been specified, like if it's ganja, how much should be drawn for sampling, then if it's chemical like methamphetamine, and if it's cough syrup, then how much sample should be drawn, all that is specified. Heard, Learned Counsel, for the appellant, Miss, your name? Also heard Mr. K. Angami, Learned PP, for the state respondent. Stop. Hearing is concluded. Judgment reserved. I need this also. No?
It's now change to 24, yes, 24. अच्छा 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 अच्छा
Hello, hello. Calling computer section. Hello.